Recording in progress.
Welcome. I had to review my decision because had I waited, we were never going to start on time. So I had to be the first in the room to welcome all of you. So there was no grand entrance. We proceed, colleagues. The time now is just 2 minutes after 2. Recognize Honorable Milam.
Thank you, Chairperson. Good afternoon, Mr. Ndou.
Afternoon, Honorable Member.
Sir, are you aware of the court judgment in the DA versus Public Protector and KSAC versus the Public Protector case in the Gauteng High Court?
Yes, I am.
And you're aware that Judge Tolme made findings that the Public Protector was wrong in fact and wrong in law with regard to the Freda Dairy report?
Yes, I am.
Do you have any comment on that?
My comment would be, Honorable Member, perhaps it speaks to the extent of the investigation in respect of the evidence and the application of the law to the facts as found in the matter. That would be my comment.
Well, let me talk a little bit about the urgency of the release of the report. In Mr. Nemesis's letter of 7th of February 2018, and I think that's LRN 15 that was attached to your affidavit,
Yes.
he indicates that there is a significant amount of information outstanding and that this should be obtainable with an eye to releasing the report on 22 February 2018. Is that correct?
Yes, Honorable Member.
So why do you think the Public Protector, having had sight of Mr. Nemesis's letter with his comments and this information that's outstanding, why do you think the Public Protector was in such a rush to release an incomplete report on the 8th of February?
Perhaps it might be due to the pressure that was in the media. But for me, there is an answer to that one, because the one thing that we could have done was to write to the DA and indicate that we are still busy with the report and there's still issues that we are looking into. We'll submit and finalize the report when we are done. I indicated last week, if I'm not mistaken, that I felt that the report could have waited until the issues identified by Mr. Nemesis were covered, although the time frame that he gave for me wouldn't have sufficed, because he did identify new issues, and which would have meant then that would have had to issue new Section 79s, and the 2-week period that he was looking at, I do not think it would have been sufficed. Sorry, it would have sufficed. So for me, I do not think that it was the right decision to issue the report on the 8th. It could have waited.
Okay, so in Judge Tolme's findings, one of the things that she identifies is that the beneficiaries, the contact details of the beneficiaries were readily available to the Public Protector. And in fact, the Office of the Public Protector had the names and numbers and even the ID numbers of at least 20 of the beneficiaries. Why weren't they contacted during the investigation?
I'm not sure why they were not contacted during the initial investigation. And at the time that the report was finalized, as I indicated last week, there was this push for the report to go out. So if it were not for that, I'm sure this could have been done in time, including other beneficiaries that would have been identified.
The push from the public protector, Advocate Mkhwebane.
And Ms. Mutsiti indicating that the report needed to be finalized that week. Yes.
Okay. Were you aware that Advocate Mkhwebane had private and unrecorded meetings with Mr. Ace Magashule during the course of the investigation?
No, I was not aware.
Do you consider such meetings with an implicated person appropriate?
If they did take place, no, I would not.
So why did the report change so significantly regarding the findings from the provisional version to the final version? And specifically, why was the comparison to market prices not done? And why was the earlier finding regarding the inflation of prices excluded? There was an earlier finding in the provisional report about inflation of prices. Why was that excluded?
Through you, Chair. Honorable Member, I wouldn't be able to speak to that because my recollection is that that change would have happened on the 8th. Okay. So I was not part of that meeting. I wouldn't be able to speak.
That was while you were on leave?
Yes, I wouldn't be able to speak to why that change was made.
Okay. Was there any evidence provided by the public protector that Advocate Cilliers was in any way biased in her investigation?
No, there wasn't.
And had she at any point prior or subsequent to the Vrede report been accused of or demonstrated any bias in her investigations?
Not that I know of.
All right. So a number of people have asked you about this, but I just want to go down a different route. You got an Audi letter for taking leave, which had been properly authorized.
Yes.
Were Audi letters a common threat to staff at the Office of the Public Protector?
I can recall two specifically that I know of.
Were people scared of getting them?
Some people, yes.
Okay. And what did that do to, well, maybe back up a step, had the use of Audi letters increased under Advocate Mkhwebane?
In my time with previous public protectors, I had not been aware of any Audi letters.
Okay.
So it's not a matter of an increase. It was almost something new, if I can put it that way.
What did that do to staff morale and the culture in the office?
Speaking of the two instances that I was personally involved in, one was the PR for the Eastern Cape, and she didn't take kindly to that, if I can put it that way. The other one related to the PR for Mpumalanga, and also he wasn't very happy about it, given the circumstances surrounding what had happened.
Okay. So we saw evidence yesterday that Mr. Sibusiso Nyembe, at the time a special advisor in the Office of the Public, or a special advisor to the Public Protector, and I'm going to use the words that were used in the tweet, that he jerked up legal services regarding the Vrede Dairy report. What was his role in the investigation or in the drafting of this report?
My recollection regarding Mr. Nyembe's involvement, the first time I saw him involved in the report, if I recall correctly, was when we were dealing with the review application by the DA and CASAC, together with Advocate Ngalwana SC. That's the only instance that I can remember. I cannot speak to other instances where he was seen to have jacked up legal services.
Okay. And do you think it was appropriate that he played that role?
Personally, I don't even understand what a special advisor, not coming from a political background, would be responsible for in the public protector's office. And I was not even aware of his qualifications. So I would have thought that would have been an issue between the team, the public protector, and perhaps legal services.
My last couple of questions.
Yes, it's your last question, not couple of questions. Your last question.
Thank you, Chairperson. In the High Court judgment, it's noted that the public protector contended in her final report that she did not have the legal power to instruct the SIU or the Auditor General to conduct an investigation. And the High Court then finds that is legally incorrect, and that there was another error of law in that she assumed that she lacked such a power and that she was aware that she actually did possess the power. Are you aware of when the finding the remedial action that it was to be investigated by the Auditor General was changed, and what prompted that change?
My suspicion is that it happened on the 8th when the report was finalized.
Okay, you don't know what prompted it though?
No, I wouldn't.
Thank you, Chairperson.
Thank you. Honorable Zagude.
Thank you very much, Honorable Chairperson. Good afternoon, colleagues, our evidence leaders, the PP and her legal team, and good afternoon, Mr. Ndou.
Afternoon, Honorable Zagude.
Thank you very much. Mr. Ndou, can you please explain to us your relationship with the public protector?
I knew Advocate Mkhwebane from the University of Limpopo when I was a law lecturer there. She was never in my class. My recollection is that she was in a class that my brother taught. I think it was criminal procedure, if I'm not mistaken. And if I'm not mistaken, we might have started in the Office of the Public Protector at roughly the same time as senior investigators. That's as far as the relationship goes.
Okay, what was your professional relationship in the office?
It was between executive manager and principal.
Okay, Mr. Ndou, the reasons I'm asking these questions, I wanted to understand from your side if you also experienced what other senior managers and employees said that they experienced under the leadership of the public protector, that they were intimidated and all sorts of things were mentioned. Did you ever experience such a treatment of being bullied by the CEO or the public protector herself, CEO Mr. Mahlangu?
As far as Mr. Mahlangu is concerned, I don't think I had any dealings with him, which I would characterize as perhaps intimidating. As far as the public protector is concerned, for me, it was just the one instance when she indicated to me that my leave was cancelled forthwith and I have to report back to the office. That's the one incident that I can recall. I can't recall any other.
Okay. Mr. Ndou, yesterday, Ms. Baloyi indicated that the PP did not provide employees with space to do their professional work. Did you ever experience that?
We're talking professional space to say as a professional, if I give you an investigation, you can run with it and then I can make comments also. Is that what we're talking?
Yes.
I can't say I have, unfortunately.
Okay. Mr. Ndou, you indicate that the PP raised concerns about Advocate Silius, who was working on the Friday report, that he was doing the bidding of the DA. This was confirmed by Mr. Kekane, who informed the committee that Advocate Silius was removed from the investigation because of this. What do you think informed this view of the PP?
Through you, Chair, I cannot point to a specific incident that I know of that would have prompted the public protector to say this to me in the telephone call that I have already spoken about.
In that very same call, telephone call that you spoke about, that the PP told you that she didn't want any adverse findings made in the report. Did she specifically mention to you what she meant by this?
The conversation, as I recall it, Chairperson, is as I've recorded it. There was no explanation. And earlier I was asked about my understanding and I indicated my understanding, but there was no explanation. It's as I recall it and as I've recorded it in my affidavit.
The reason I'm asking this question, I know that my colleagues did ask this question, is for us to have a better understanding of what exactly did the PP say. Because Mr. Gekana and Mr. Samuels said in their testimonies before this committee that the PP did not want any adverse findings against politicians. So as a person whom the PP spoke to, we want to understand from yourself, because you conveyed the message to the others. So want to know exactly the exact word. What did she say? Did she expressly say this to you during the call, that she did not want any politicians involved, implicated, I mean to say?
Through you, Chair, as I indicated in the morning, the communication to me was expressed in the sense that she would be happy if there are no adverse findings. And I indicated in the morning, Chairperson, that for me, that would include politicians. Perhaps the other witnesses are specifically speaking to incidents that they might have witnessed. I indicated that for me, to restrict it to politicians is actually a restrictive interpretation of what she said to me, because she said adverse findings, and that would include politicians, obviously, but there was no specific mention of politicians. It was very wide. That's how I recall the conversation.
Okay, thanks to Mr. Ndou. We have had evidence that the incumbent PP abolished the think tank, which was used as quality assurance mechanism to assess reports before they are released. In your observation, did the abolishment of the think tank have a negative or positive impact on the quality of reports released?
My sense is that the think tank, being a wider body of all the managers who are legally qualified, had a more positive impact on the kind of reports that went out of the Office of the Public Protector. So my sense is that the smaller task team would have not had the same kind of effect on reports as compared to the task team, to the think tank.
Okay. We also heard from the evidence of Mr. Gekan that the draft report of the free diary, the initial draft report, which was produced by the PP's predecessor, Advocate Madonsela, was changed. Were you part in the changing of that report?
The report that I personally worked on, if I'm not mistaken, is dated September 2017. And that's the report that basically went to the public protector and to legal under Mr. Nemesis. I can't recall being part of a meeting that specifically changed a report unless it related to looking at the evidence and the findings and comparing if then the findings are supported by the evidence.
Okay. There were also allegations made by Mr. Kekan that the Gupta leaks emails were excluded in the reports, though they were going to assist also with the investigation. What is your take on that?
Chairperson, I already spoke to this issue in the morning, but perhaps it bears repetition. My take, and I just need to indicate that Mr. Kekana might have taken this from the email that I sent to the task team, alerting them to the fact that the Gupta emails, as far as the report is concerned, were deemed to fall outside the scope of the investigation. And my take then was that it could have fed, or some of the contents of the Gupta emails could have fed into the investigation, specifically as it relates to how the funds that went into the dairy project were then used and so on. So that was my view, that it could have, if for example, we looked at the bank statements of Estina and so on.
Okay, my last question, Honorable Chairperson. Mr. Ndou, in the Office of the Public Protector of South Africa, there were many leaks of reports before they were actually released. And Mr. Kekane felt that he was wrongly accused of leaking those reports. As a senior person in the office, what would you say about the leakages of reports, the leaking of reports before they were released? Because previously it wasn't like that. Was this some sabotage from other staff members, or what is your take on this?
Through you, Chair. My recollection of Mr. Kekana's, I'll respond to the question. I just want to clarify something. My understanding of Mr. Kekana's charges did not relate to the leakage of a report, if I'm correct. But on the issue of leakages of reports, we've heard that even before Advocate Mukwebane's time. I did indicate in the morning that the reason why we did away with so-called provisional reports, which were during Advocate Madonsela's time, was because reports would then be leaked, and then we ended up doing Section 7(9)s. Leakages had been happening even before that. And partly it might be, for example, if I get a provisional report which says my complaint is substantiated and so on, I might actually leak it before the final report is signed off and so on, so that it's out there in the media. Then the public protector would need to explain why then it has changed and so on. But the issue of leakages even goes before the current public protector's time.
Thank you.
Okay, thanks, Honorable Chairperson.
You get your time. Thank you.
My apologies.
Honorable Siwela.
Thank you, Chairperson. I'm clear because you want to see our photos. Chair,
Yes,
greetings
please
to your good
proceed.
self and
We
my
can see you
colleagues,
now.
as well as Advocate Mpofu and the PP with their team, as well as our evidence leader and her team. Absheni Tatanando.
Abshe,
Minjani.
Ifukile minjani?
Ifukile. Se le rara ka n'wanda ha ri tivi kahle kumbe ni ta ku ndanta va ni vula swo a hi swi tivi. Na ti-question nyana titsongo leti ni lavaka ku ti vutisa, although se swo tala ni coverekile, but there are a few issues which I would like to ask you in relation with the OD letters that employees of the OPP were served with. We were informed by Mr. Nsailele that this was the responsibility of line managers. I believe that you are one of them. As a manager, have you ever served your subordinate with such? That's my first question.
Through you, Chair. Yes, I served two. One to Advocate Thomas in the Eastern Cape office. The second one to Mr. Sitole in the Mpumalanga office, yes.
If I may make some follow-ups on that one, on those issues of letters. In any way, have these letters have an impact on the moral of the employees? What is your view on this one? What impact did this have on the quality of work produced by these employees? Maybe if we can be assisted on that one in this regard.
With regard to Advocate Thomas, after I issued the Audi letter, she actually had health problems, And after the letter was issued, the audit letter was issued, she indicated that she felt that given her health issues, she would like to put a request to the employer to be redeployed to go and serve in the regional office in Mthatha, because she couldn't cope with the demands of the provincial office. There was no discussion about the impact that it had on her. But with Mr. Sithole, my recollection is that it did have an impact, because the reason that the audit letter was issued related to not meeting targets relating to outreach. And at the time, there had been an EXCO decision to say outreach clinics should not be conducted in the way that we used to, because the office was under financial constraints. So in respect of Mr. Stolle, I know it did have an impact on his morale.
Thank you. The last question is based on your experience working in the OPP. By explicitly without reason, excluding adverse findings in the report, did the PP act in a manner that sought to undermine the mandate of the OPP in any way? In this regard, did the PP fail to act in an impartial manner? I just want you to maybe to assist us, since you are a legal guru. Thank you. Thank you, but Reginald.
My sense on this one, Chairperson, is I indicated in the morning that it did surprise me that my principal would express a wish that there are no adverse findings in this matter, which then for me spoke to the issue of whether there is impartiality, whether it's perceived or real. But beyond this discussion that we had telephonically, I cannot point to a specific incident or instance which then said to me she was undermining the mandate of the office beyond this very conversation that I've discussed.
Thank you, Chairperson. Thanks. These were the few questions I wanted clarity on. Thank you.
Thank you. Honorable Zungula.
Thank you, Chairperson. Thank you, Chairperson. Let me greet the honorable members, greet the PP. Absheni Tatana Ndou.
Absheni, Mr. Zungula.
Yeah, I think my first question would be, did you ever tell Kekana that the PP accused Advocate Silias of being a member of the DA?
My recollection is that I indicated to Kekana and the other task team members the whole conversation as I've recorded, yes. That would include the issue of the adverse findings and remarks pertaining to Advocate Silia.
So it's you who told Kekana that, okay, no, let's proceed. Then you have testified that the
Honorable Honorable Zungula, just a pause. We have just checked your network is very poor, so just switch off your camera.
Is it better now, Chair?
Just switch off your camera so that it can be better. Thank you. Go ahead.
Is it better now, Chairperson?
Much better. Thank you.
Okay. So, Ndou, so people express a general desire findings would be made with any specificities. Is that correct?
Chairperson, I'm getting bits and pieces, so I didn't get the whole question.
Just repeat the question, Honorable Zungula.
You testified that the PP expressed a desire that no adverse findings would be made without reference to any party, meaning the PP was not specific.
My testimony, Honorable Zungula, was the desire that the public protector expressed was not specific to politicians. I did not speak about it not being in respect of a particular party. I just need to clarify that, Chairperson.
All right. Then why do you think Mr. Kekana and Mr. Samuel were specific to say the instruction was to exclude politicians? Because in testimony, you say the PP was general. However, these two gentlemen stated that the instruction was to exclude politicians. Why do you think so?
Through you, Chair, I've indicated in the morning and a bit earlier that for me, adverse findings relate to anyone, whether it's a bureaucrat or politicians. And I did indicate that perhaps in their interpretation, then they restricted it to politicians. When I listened to Mr. Samuel's evidence, for example, he indicated that there were subpoenas against the then Premier and the MEC that the public protector refused to sign off on. So that might actually be why he's restricting it to politicians. Advert findings would include whether it's a politician, a bureaucrat, and so on. So maybe that is where it's coming from.
Okay. So in light of your explanation, would you say perhaps there are disgruntled employees or former employees who would seek this, who would utilize this process, Section 194 process, to exact revenge on the PP?
For me, as a legal person, I think people will speak to their own experiences. I cannot really speak to their motivation. Our responsibility, as I see it before this committee, is to come to speak to what we know. I cannot really speak about disgruntled employees, ex-employees and so on.
Okay. As per the email that was shown by Advocate Mpofu, which relates to the Gupta leaks and the correspondence between the PP and the lead investigators, would you agree that the PP had opened up the scope of the investigation enough for you to explore all avenues for you to investigate?
With hindsight, I would say yes, but I wish the PP had shared that email with me when I indicated to her that I was still a bit unsettled about the Gupta leak emails. I'm only seeing that email today, but it gives the sense that she had opened the investigation.
Okay, so the narrative that she narrowed the investigations, would you then say that narrative is false?
Given the reports that I've seen, Chairperson, and the email that was shared with me this morning, I'm not sure that based on those facts, we can say that there was a narrowing of the investigation, especially given the email that was shared with us this morning.
Okay, no, let me maybe rephrase my question. The narrative that is out there is that the public protector wanted that investigation to be narrowed, and it must exclude certain people. However, from the email that has been shown today, would you agree that that narrative is false because the PP gave an instruction that opened up the scope of the investigation?
For me, that would be a valid argument, yes.
Okay.
To say that, yes, that she had opened it up, given that email that was shared this morning.
Okay. Now, you made mention of calls that you received from the PP, right?
One call, yes.
Yeah, one call. Now, do you have any form of evidence that would support that call, even if it's a screenshot from your conversation, from your call log? So do you have any evidence to back up that assertion?
I was asked, Chairperson, to obtain my telephone statement from the service provider, which is Telkom. And I did write to them, but they have not come back to me. So I do not have a statement that reflects the call, but the call did take place.
So, but you don't have evidence as we sit here now?
Not of the telephone call. What I've recorded in my affidavit is the contents of the conversation.
Okay. All right. Let's move on to the last question. You do understand maybe that there's this narrative that seems to suggest that the PP victimized and harassed staff members. And you also claim that you were unfairly targeted by the PP. Is that correct?
Chairperson, I've not claimed to be targeted in my affidavit. And I think perhaps in fairness to me, the employees, whether it's current or ex-employees who feel that they were targeted, they should be able to speak for themselves. I cannot really speculate on that one.
Okay. So, no, I know that it is Mr. Samuel and Kekane who say they were targeted. So, from your perspective, why did you leave the office of the PP?
I resigned to go and attend the practical legal school, which I did in 2019. And I also wanted to start my own company, which I did register. And I had plans to go into business with a former colleague of mine who is from KwaZulu-Natal. And that is what I went to do when I resigned.
Okay, so you did not leave because you were harassed or targeted?
Not in my case, no.
Okay. Is there any other issue?
That will be your last one.
Okay, thank you. Is there any other issue that would have transpired between yourself and maybe another employee that would have pushed you to actually resign and leave the office of the PP?
The issue that you are referring to is the allegations that were made against me. And for me, based on the facts that I knew, I had no fear that I couldn't answer to the allegations. One, I was exonerated by a report of a top law firm. Two, there had also been a criminal complaint by the complainant in this matter. When I was on suspension, I just want to put this on record, Chairperson. When I was on suspension, I got a call from somebody who works for a unit in Pretoria East that deals with such matters, that they'd actually collected the docket in the criminal matter, and that I should go and report to their offices the following week. The following week, they called me to say they had looked at the docket. There was no merit in the allegations. Then they sent it back to the Brooklyn police station where it was investigated, and the prosecutor declined to prosecute. So in short, what I'm saying, Chairperson, for me, that issue I could have responded to. So I didn't leave because of that issue.
All right. No, thank you, Chairperson. Since you said it's the last one, but I would have loved to actually go deeper into this issue. Thank you.
Thank you, Honorable Zongola. I can give you a bonus for the last one.
Okay. So, Ndou, so you're saying that was not the reason. In fact, no. Okay, no, it's fine, Chair. It's fine. Let's leave it.
Thank you. My bonus worked. Thank you.
Thank you, Chair.
Honorable Skosana.
No, thank you very much, Chair, and good afternoon to everyone. Mr. Ndou, how are you this afternoon?
I'm okay, Honorable Skosana. Yourself?
No, I'm also fine. Mr. Ndou, in reference to paragraph 12 of your affidavit, do you agree that the information that the PP shared with you through a phone call was controversial?
Yes, I do.
All right. Do you know of any other person that the PP shared such information with other than yourself?
I do not.
Okay. So why did the PP choose to share such information with you out of all people?
I wouldn't know, Chairperson. Perhaps it's because I was responsible ultimately as the executive manager responsible for provincial investigations. That would be my suspicion.
But were you a person that the PP normally confides to?
No, in my recollection, in the time that I worked with the current PP, I think we might have had only 2 telephonic conversations.
Okay. So what was your response to the PP in that particular phone call?
I did not respond, Chairperson.
You just listened only.
Yes, Chairperson.
Okay. So in your email of the 11th of September 2017 to the PP, which is also highlighted under paragraph 26 of your affidavit, you made a good argument in the last paragraph of that email, where you said, just to quote it verbatim, where you said, as an institution, we just need to have cogent reasons why this avenue was not explored, especially since we make reference to them in the one-liner in case we are taken on review. But now, this is the matter that you are raising in your affidavit. I mean, in your affidavit, if you look at paragraph 27, you are saying, in referencing to Maid and Guardian case in my email, I was referring to the fact that the Supreme Court of Appeal had already indicated that the PPSA had to follow wherever the investigation leads us. We could not be confined simply to the complaint. That's what you said in your affidavit. But in the body of the email, in the email itself, I think there's no mention of the Supreme Court of Appeal. You are arguing about the fact that as an institution, you need to have cogent reasons why this avenue, the avenue in relation to the Gupta leaks, why this avenue was not explored, especially since we make reference to them. But we are not talking specifically about the fact that already there was a ruling of the Supreme Court of Appeal that speaks about the issue of following the investigation wherever the investigation leads you, that we need to follow the investigation. We are not supposed to be confined. Why in this particular email you are not specifically making reference to the Supreme Court of Appeal ruling?
Chairperson, but I did refer to the case. It's the Mail and Guardian case.
You're also speaking about specifically the ruling of the Supreme Court of Appeal in the email itself, not in the affidavit.
Chairperson, I'm not sure I understand what the question requires of me, so I'm struggling. I thought the honorable member was saying I only refer to the Supreme Court of Appeal matter in my affidavit, but not in the email.
Not in the email of the 11th September. Okay, let me rephrase my question. Does the email of the 11th September also speaks about the Supreme Court of Appeal ruling?
Yes, it does.
Okay. All right.
It's referring to the same case during Mr. Advocate Mushwana's time.
Oh, okay. All right. The next question is in relation to your leave. Who approved your leave that you are referring to in paragraph 41 of your affidavit?
The acting CEO, Ms. Ntoriseng Mutsitsi.
Okay. So was the public protector having powers to cancel such a leave?
Chairperson, I have not really looked into the legalities of whether the public protector is the executive authority would have been within a rights to cancel my leave. But my own view, legally correct or not, was that I was on approved leave, which had been approved before I was made aware that the public protector wanted to discuss the matter.
Okay. So didn't you find it necessary to inform the PP directly that you are going on leave for 2 days, since at that particular time you were working closely with her and other members of the task team to finalize the Friday report? Didn't you find it necessary to inform her?
Usually, the information would be to my supervisor and not to the public protector.
Yeah, I understand that that kind of a protocol, but I'm just saying that because at that particular period, you were working very close with the PP and the other members of the task team dealing with the Friday report. As much as there is the protocol of reporting to the next senior person, but by the mere fact that you were during those days working very closely dealing with this Friday report, didn't you find it necessary just to indicate to her that I will be on leave for 2 days, which has already been approved?
Chairperson, my own sense with hindsight, the public protector was at the time out of the country, and my communication after the SMS that the public protector sent on the 5th had been through the CEO, because it's the acting CEO, sorry, because it's the acting CEO who kept on saying, where is the report? The public protector would like to see the report. So my sense was that I was liaising through the acting CEO.
Okay. Then did you respond to the SMS or WhatsApp from the PP that said to you, your leave is cancelled and that you should return to work immediately? Did you respond to that SMS or WhatsApp?
I don't recall responding to it.
Okay. So you might have responded.
I doubt that I responded.
Okay. So the next question, Mr. Ndou, did you ever get a sense that employees were patched at the PPSA, particularly those who spoke out against things they perceived to be wrong?
During my time at the public protector, the only employee who had been fired was an Eastern Cape senior investigator, if I'm not mistaken. All the other employees whose names are mentioned in the affidavit, that was after my time at the public protector's office, so I really didn't follow that much.
Okay.
That happened after I left. Yes.
All right. So under cross-examination, you indicated that the PP said there was no harm in looking at the Gupta leaks. But in paragraph 29, you indicated that the PP specifically told you that they were not to form part of the investigation. And you further indicated that I think during lunch break, Mr. Tebele and Mr. Nemesis also told you to let it go as they tried to raise the issue with the PP, and she shot it down. So what do you think changed the attitude of the PP in this regard?
Chairperson, my own sense of this one, and I think we can refer to the email that was sent in the morning. My sense, when the PP indicated that we can look at the Gupta emails, was that the lead investigator then had said we need not go to the Gupta leak emails because the complainant was only interested in matters of maladministration and so on. And it was my sense that perhaps this was not the right approach. And so I then wrote to the public protector. And as I said, I did not receive a response according to my recollection. And I did raise it, I remember, at the meeting, and I remember the PP saying we won't be looking at the Gupta emails. I wouldn't know why she would have said that.
Okay. Yeah, my last question, Chair. Mr. Kumbi Chelela stated in his affidavit that you were one of the persons that sat on the panel to appoint a senior manager for security management, and that there was also a representative from SSA. I think it's Mr. Prince Makutama. So the question is, was there anything unusual about having a representative from the SSA on the panel?
For me, it was unusual, yes, given the role and responsibility, as I understand it, as an ordinary citizen, having somebody from state security sitting in such a meeting.
Okay. No, thank you, Mr. Ndou. Thanks, Chairperson.
Thank you, Mr. Skosana. Honorable Tseke.
Thank you very much, Chair. Yes, thank you, Chairperson, and good afternoon. Good afternoon, Tate Ndou.
Afternoon, Honorable Mtseki.
Lekai Tate Ndou.
Awarona lekai.
Orvona. Most of my questions has been covered. Just 3 questions that I have. Mr. Ndou, how important was the outreach program, given the fact that at some point you headed the division dealing with outreach programs?
Chairperson, outreach in the public protector is very important because it comes, it is really a practicalization, if I can use that word, of the injunction in the Constitution, which says the public protector must be accessible to all communities and people. I think it's section 182.4, if I'm not mistaken. So outreach was really our way then of giving effect to this section in the Constitution.
Thanks very much. My next question, do you believe it was unreasonable under the circumstances for the former CEO, Mr. Vusma Tlangu, to pursue charges against you 15 months after you were cleared from wrongdoing by you refer them as the top law firm, and after you had resigned?
Yes, I am. I think it was very unfair.
Thank you very much, Mr. Ndou. My last question, do you believe the overall conduct of the PP in any way weakened the office of the PP considering the exodus of many experienced people who had institutional memory, her managerial style, as evidenced by Mrs. Baloyi yesterday, and the manner in which she handled investigations.
Chairperson, I don't think I caught the direct question properly. Perhaps if the honorable member can just repeat the question.
Okay, thanks, Ndou. Do you believe the overall conduct of the PP in any way weakened the office of the public protector, considering the exodus of many experienced people who had institutional memory, her managerial style, as evidenced by Mrs. Basani Baloyi yesterday, and the manner in which she handled the investigations? Did you hear me?
Yes, the Chairperson, I heard the question. Chairperson, I think for me, this is a case-by-case issue. I would have to know the facts pertaining to each and every person who left the office because of the conduct of the public protector. And I would really be speculating if I said I agree, because I don't have all the facts pertaining to all the people who are indicated as having been of having left the office because of the conduct of the PP and how she conducted investigations. I would really be entering the realm of speculation, unfortunately.
Well, thanks very much, Chair. I'm done.
Thank you, Honorable Tseke. Honorable Tlape.
Thank you, Chair. The Chair will really plead for indulgence. Network is showing me flames this side. Dumela Ntate Ndou.
Dumela, Honorable Tlape, although I'm struggling to hear her properly, Chairperson.
Oh, network is showing me flames. Let me also acknowledge and greet the PP and the team. But then though, let's go back to the issue of the Gupta emails that we didn't see. According to the way you're testifying, you didn't see the Gupta emails. Did you see what was being said by the media at that time about those emails?
Sorry, through you, Chairperson, I'm getting snippets here and there. I didn't get the gist of the whole question.
Okay, just get closer to the mic a bit, Honorable Tlape. There's a bit of an echo.
But then though, you testified that you did not see the Gupta emails. I was just trying to find out from you, did you by any chance see what was being said by the media at that time about those emails?
Thank you, Chair. I've got the question now. I did see some of the information that was contained in the media about some of the emails. And I even looked at the Amapungane website just to see what the emails might contain as it relates to the Friday investigation, yes.
Would you say they were relevant?
those that pertained to the issue of how the funds were utilized for me, they would have been relevant, yes.
Thanks, but now you also said that financial constraints were a factor in other reports. What about the Friede investigation? Do you say it couldn't have proceeded also because of financial constraint?
Chair, in the morning when I was responding to questions, I said, for me, the Public Protector's Office has always had financial constraints. I mean, every time we came to present to Parliament, we would be asking for more investigators, for more funds, and so on. And I did indicate that my evidence was to say I did not specifically see anything that would make the Friede investigation subject to financial constraints that would not apply to any other report. That was my evidence, Chairperson.
Mr. Ndou, you also denying the allegations that is being made by Ndou Samuels that you could have been patched for a lack of better word. Why would you think Ndou Samuel will make such an allegations that you don't know anything about?
Perhaps Mr. Samuel thought because just before I left, charges were preferred against me on the 16th of November after I had resigned. Perhaps that is where it's coming from, Chairperson.
No. There's also indication, like my colleagues has said, that complaints and allegations of intimidation, harassment and everything, it looks like the Public Protector would go just down directly to employees. What will you say as an executive? What was the role of line managers or direct supervisors in regard to disciplinary matters?
Chairperson, if you may repeat the question with your indulgence, please.
You missed that again. Just to repeat your question, Honorable Tlape.
I was saying that the allegations that arise of intimidation, harassment, gives an indication as if the Public Protector would go down or directly to employees. As an executive, what was the role of line managers or the direct supervisors in terms of disciplinary matters?
I'll answer the question as far as I understand it to, well, let me just say as far as I understand the question, Chairperson. The role of line managers obviously is to manage performance, and if there is lack of performance or any other thing that is untoward in terms of the policies of the organization, then the line managers are responsible then for taking action, if that is your question, Honorable Member.
Thanks, that I just wanted to understand, because it's like I'm saying, it's like the Public Protector was going direct. Hence, I wanted to know where were the line managers or direct supervisors. My last question, Chair, Ndou, still as an executive manager, would you say certain deadlines that you spoke about was a bad thing, or how did it affect the working relationship, the setting of deadlines by the Public Protector?
For me, Chairperson, as it relates to investigations, sometimes investigations can have a life of their own. You can, for example, think you can finalize an investigation within 3 months. And as you embark upon the investigation, it takes a life of its own and so on. So sometimes some of these deadlines would actually have an impact on employees in terms of when something had to be delivered. That would be my response on that one.
Thanks, Ndou. Thank you, Chairperson.
Thank you, Honorable Klape. We understand that and we can see your network is very unstable. I don't have any other member. Mr. Ndou, just perhaps 3 small areas of clarity that you can assist with. Mr. Samuel reported to you, am I right?
Yes, he did, Chairperson.
Were you informed that he was facing criminal charges?
Yes, I was, Chairperson. With your indulgence, if I can just indicate something else. Initially, when this whole matter started, I became aware because he made a submission for the office to pay for his traveling. That would have been around the time that this incident took place. And even when it was reinstated, if he wanted to take leave, he would indicate to me, yes.
And you are also aware of the final outcome?
He did indicate to me that he was found guilty and that he had appealed the matter.
Okay, thank you. Was there a practice or policy that the Public Protector Office does not investigate matters that are being dealt with by other bodies?
You mean administrative investigations, the kind of investigations that the Public Protector undertakes?
Yes.
There's always been an understanding that resources come from the state, from the same fiscals. And if a matter is being investigated elsewhere, there is no need to duplicate investigations, at the expense of the fiscals, yes. It's not a policy as such, but it is the practice, yes.
It's a practice.
Yes.
Okay, no, thank you. The last quick clarity, just want to assist me with this, your approved leave, which was signed by the CEO.
Yes, the acting CEO, yes.
Yes. Did you have a sense that there was no communication from the acting CEO to the Public Protector to report the fact that you are on leave?
I did not have an indication, Chairperson.
So how did it work in that office? Because you report to the CEO, you apply for a leave, it gets approved. Does it end there with the CEO as an accounting officer, that an executive authority would not know people that are under her office or his office? How does it work?
Chairperson, in the various instances that I've acted as CEO in that institution, now I'm speaking to something that I can speak to personally.
In other words, you wouldn't have weekly meetings or whatever where you report. These are matters that are happening in relation to staff, to as an acting CEO now to your boss, who would be the PP.
I don't think the issue of which executive manager would be on leave would be one of those matters that would have been reported. I don't think so.
So it will be fine if the PP does not know who's gone AWOL, who is on leave, either for being sick, for study leave, or other leave. You're saying that doesn't matter. It didn't feature.
That's not what I'm saying.
So I'm asking, why would such not feature when you are interacting with as a acting CEO or CO when you're acting with the executive authority?
Chairperson, I honestly do not recall an instance where one of the reports to the public protector would be to say this executive manager is on leave, this one is on leave, and so on. Yes.
Put it this way: if you met on a weekly basis in that position of CO, acting CO, and when you meet with the public protector, what are the issues on the agenda? Or you just meet and greet, have tea? What are the issues that you're meeting with the board? So otherwise, I'm looking for the importance of this meeting that this CEO, acting CEO has with the public protector. If it's a weekly basis, yes. It's fortnightly, yes. If it's daily, yes.
Chairperson, I cannot recall the frequency.
Never mind the frequency, just the content of what gets to be done in that meeting.
Chairperson, in my acting, I don't recall a meeting with the public protector on a one-on-one, except when it was at EXCO.
How long did you act?
I think in my case, it was 2 months.
So for 2 months, you never had a meeting with the PP as an acting CEO? You just said you never recalled.
Yeah, I'm saying, Chairperson, the only meetings would be the top, management meetings with the CEO, the PP, and perhaps the DPP, but not one-on-one. I don't recall such a meeting.
So finally, from my side, so from your version of how you explain this, am I right to say it is possible that the public protector did not know that you're on leave? Just based on what you're saying.
It is quite possible, yes.
Okay, so you wouldn't be surprised when he or she recalls you back because she was not aware that you're on leave. You just indicated that never done in meetings.
But then she in a SMS, she did specifically speak to my leave. So she must have spoken to the acting CEO.
Accidentally, I'm sure.
I would
just based on your version of the report.
I wouldn't know a chairperson.
Okay. Thank you, Mr. Ndou. Advocate Ndou.
Yes, thank you, Chair. Just with your indulgence, can I just ask one issue that arises from your...
I will give you and then I go to Advocate Bauer.
Thank you very much, Chair. I appreciate that. So, Advocate Ndou, the Chair has actually assisted. There's an issue which was on my list, which I didn't ask you about. When Mr. Samuel reported to you that he had been found guilty, did he suggest that this was a secret between you and him, or was he just reporting to you?
He was just giving me feedback.
Okay.
Yes, after the court case.
Thank you. Oh no, that's fine. Because I was asking that because he suggested that. Or rather, he gave the impression that he didn't tell anybody because his suggestion, I can't even remember whether it was direct or indirect, was that the public protector would have only known about that because of some links with the SSA or something to that nature. So it was never conveyed to you as something that you must not tell anyone.
As far as I recall, it was just feedback because whenever I took leave, you would indicate to me I'm attending the case. Yes.
Of what has happened. And did you not see any need yourself, or did you expect it for him to do it himself. Did you not see any need for yourself to report it upstairs? I'm just using that term. In other words, to report it to anyone else.
Hierarchy.
To the organization, yes, in the hierarchy. Because it was obviously an important event for someone to be found guilty of a criminal offense.
Chairperson, if I recall, I had not decided then until the outcome of the appeal to report it any further.
Okay. Thank you, Chairperson.
Thank you for that bonus that you got. And just before I go to Advocate Bao, just the last point, it's not linked with that. Just back to Advocate Cilliers, and a very quick one, because it's been suggested here that he was conflicted, or it comes across as such. Was Advocate Cilliers given an opportunity to respond to allegations leveled against him?
Chairperson, my recollection is that I just indicated my conversation with the public protector to Advocate Cilliers. It was not a formalized thing to say this is what was said, then you need to respond. That was the level at which it was left, Chairperson.
Okay. Lastly, as a general point, I always leave some of the witness with, so that you can just help this committee in its report. And it is not, you remove the person. And I'm triggered by the kind of question. There seems to be a lot of informality in your institution. Would you share one or two things that you think this committee needs to be concerned and take care of in the institution, which would make it difficult for any incumbent in that office to do their work properly?
Chairperson, just off the top of my head, I think perhaps for me, the issue of Audi letters, from my understanding of performance management, how you deal with performance, for example, I'm just specifically relating this to performance, is you seek to assist the employee, and then disciplinary action then follows after you've assisted the employee. But the way the narrative and the conversation goes around in the Office of the Public Protector is like these Audi letters. It's like, as the employer, I've already, come to the conclusion to say you have done something wrong and so on and what have you. Perhaps there needs to be a shift. I'm not saying there should never be disciplinary action against employees, but not every instance, for example, should be an Audi letter and so on. You might want your managers to say, sit down with your employee and find out what are the issues, why is the performance lacking and so on. Because I think Advocate Mpofu in the morning spoke to an Audi letter being equivalent to a Section 7.9. Now, when you look at the Section 7.9...
And I'm interested why you're suggesting a shift, because the version I have of you on the Audi here is you affirm the Audi letters, legally sound, and depending on how people look at them. So I take that away here. And I'm not sure what shift you're suggesting that they looked at as opposed to the version you've placed here.
I'm just saying, Chairperson, perhaps the narrative should not be, Audi letters should be the default position, which might create perceptions amongst employees to say, if I put my left foot wrong, this is what is going to happen. That's the kind of, at least maybe perhaps just the narrative internally and so on, so that employees begin to see as well, to say, when I get an Audi letter, it's not a way of punishment, but it's to assist me, to better my performance and so on. That's the kind of shift in the narrative that I'm speaking to.
Thank you. Advocate Bauer, in terms of 616 and 617, do you have any questions?
Yes, Mr. Ndou, I've just got a couple. But just picking up on that last point, I understood you to agree that an Audi letter was akin to a Section 7(9) notice because you're giving both parties a hearing. But as I now understand, what you're saying is in Section 7(9), you're giving notice to what is already regarded as an implicated party. But with your employee, you must attend to performance rather than implicate them in a disciplinary process. Is that what I'm understanding you to say?
That's the narrative that I'm trying to push.
Okay.
Yeah, that might improve at least internally.
Right.
That's what I'm saying.
You also agreed that there was pressure from the DA. Now, the only as being the push to get the Vrede Dairy report done in February as being one of the reasons. There's two kinds of inputs from the DA as far as what I could understand pressure to be. There was a letter dated 31st of October 2017. I don't know if it was put to you. I'm just going to ask Shepard to put it on the screen to see if you know about it. That's 5 months before February, where there's a request about the letter, about the report being released. And then there's a meeting with Mr. Mayamani where he brings some beneficiaries at some point in November. Are you aware of any other pressure that necessitated the report to come out in that first week of February?
You mean besides the meeting with then Premier Magashule?
No. Well, this is a letter from the DA.
Yes, I've seen the letter, yes. Mm-hmm.
The proposition was put that there was pressure from the DA for the report to come out. Right?
Yes.
So now I'm asking you, you agreed that there was pressure from the DA? I understood, let me rephrase that. Did I understand your evidence to be that you agreed that there was pressure from the DA?
I would say to an extent, yes. Because I recall there was one time that the then Mr. Maimane came to the office, and if I'm not mistaken, he had the media with him. And it was a bit of a spectacle in the reception area. So for me, from that point, obviously, it said to me, there is a bit of pressure to release the report. The letter, obviously, I was not privy to. But for me, the meeting subsequent to that, I think in November that you referred to, would have then lessened the pressure, because if I come to you to say, release this report, but then I say, I've got more information for you, I'm actually saying to you, I'm giving you more time to look at this information and then factor it into the report.
Right. So that is the meeting that takes place around November when Mr. Maimane comes to the office, correct?
I can't remember the month, but he did come to the office, yes.
Was that the meeting where he came with a number of the beneficiaries?
Yes.
So there's only one meeting. What's Mr.
I can't recall whether the day that I saw him with the media downstairs would have been the same day. It might actually be two different occasions, but I speak under correction.
And you're not aware of any other events besides those?
Not that I'm aware of, Chairperson.
Okay. Then you were referred to an email which was sent on the 17th of July.
2017.
2017 by the PP. Let me just see if Shipper can get that on the screen. The 13th of July, sorry. This was an email which the PP sent to the PPSA CEO, Mr. Hamilton, Ms. Saliers, the acting chief of staff, and Ms. Mokhaladi. And this is July 2017. And the instruction to the CEO, who would have been the CEO in July 2017?
It might have been Mr. Temba Dlamini.
Okay. There's an instruction. Follow up with the Free State PR to prepare letters to the Premier, the MEC, and Minister Zwane for my signature regarding the below Gupta leak allegations. Have you ever seen such a letter?
Have I ever seen such?
A letter to the Premier, the MEC, and Minister Zwane for my signature regarding the below Gupta leak allegations.
I don't recall seeing the letters, Chairperson.
Right. This in addition to the Section 79 letters issued. You've never seen it?
No, I don't recall seeing them, Chairperson.
Right. This is in July, and the reason why I'm raising it is because the following month is August. There's an August think tank meeting. But read a bit further. I will give you the hard document submitted by Outer. Have you ever seen the document submitted by Outer?
I don't recall seeing them.
Because there's no such documents included in the Rule 53 record. Did you not see any of those documents submitted by Outer?
I don't recall seeing them, Chairperson.
Right. And then there's certain allegations, Estina, KPMG, and the wedding expenses, the Free State government, etc., etc., etc. Just go down. Stop. The Guptas denied involvement, we now know they lied. You were not, this was not raised at the think tank meeting the following month at all.
I don't recall it being raised.
So if this was not carried out by an investigator who was given an instruction, what then happens? If those letters were not prepared, would there have been a request for such letters to be prepared?
If that's the public protect such instruction, yes.
And so what happens when you don't carry out that instruction?
Action would have to be taken.
Thank you, Mr. Ndou.
Okay. Thank you, Advocate Bauer. Mr. Ndou. Mr. Ndou.
Yes, sir.
We still have time, but we have reached the end of our session with you. Do you have anything to say to the committee? Any final remarks from you?
No, Chairperson. I don't have, I've said everything that I wanted to say. Thank you for the opportunity.
You sure?
Chairperson, I came here.
That's okay.
After being requested to come and give evidence to the best of my recollection, and given the time that is elapsed and the fact that I last looked at the investigation file a few years ago, as I indicated in my affidavit. My memory may be hazy here and there and so on. So that's just the one aspect that I want to leave with this committee, and to wish you the best deliberations and process going forward in this matter. That's all I need to say right now, Chairperson.
Thank you, Mr. Ndou. On behalf of this Section 194 Inquiry Committee, we want to thank you for availing yourself before today and before last week, and for both coming, presenting yourself Friday as well as today. We hope that your contributions and what you have placed here would be of assistance to the work that we're doing in our deliberations. Thank you very much. You are now excused.
Thank you, Chairperson.
Colleagues and everybody else, the meeting is adjourned. And in the spirit of today's meeting, all rise.
For the chair.
Recording stopped.